Many of you watch my videos about the Alex Belfield trial and the sentencing. Many of you sent me comments and questions, and I fed back in other videos, which I will link below, about that sentencing and how it worked. Many of you since have asked about any prospects of appeal and whether an appeal has been lodged. And obviously an appeal was lodged, and I can update you that there is 2 stages to an appeal, the second of which at the discretion of a defendant within 14 days of the first. So in this video I will talk a little bit about what those mean and the potential risks of doing so. So when somebody appeals their sentence, they first need to obtain permission. This is called permission to appeal. And the applicant applying for permission to appeal doesn't have a right to attend this application, but first of all it's considered, as we call it, on the papers. All that means is that the papers are sent to the appeal court from the Crown Court, outlining the case and the sentence and so on, and a single judge in the first instance will make a decision on those papers as to whether permission to appeal should be granted. If permission to appeal is refused, then it can go to a full court at the discretion of the applicant. That must be done within 14 days. Now, it was reported earlier this month that the application for appeal has been refused by the single judge. The court did confirm, however, what I've just said, which is that he can renew the application before a full court. So this is very much still a live case in the criminal division of the Court of Appeal. For those of you that were not too familiar with the case, there were 8 counts of stalking, of which Alex Belfield was acquitted of 4 and convicted of 4. On count 5, it involved Bernie Keith of BBC Radio Northampton, and Alex Belfield was found guilty of stalking to cause alarm and distress and given a 2.5-year sentence in respect of that count. In respect of count 6, this was a videographer called Ben Hewis, and Alex Belfield was found guilty of stalking to cause alarm and distress, and this was to run consecutive with the sentence for count 5. Consecutive meaning one after the other, not at the same time, because sometimes if a defendant is convicted of 2 counts, they could run concurrently, meaning that if it's 1 year and 1 year, then the whole sentence is 1 year in overall duration, of which they serve half. In this case, however, those sentences were to run consecutively, one after another, obviously lengthening the time that Alex Belfield would spend in prison. Count 7 related to Philip Danny, and Alex Belfield was found not guilty to causing alarm and distress, but guilty of simple stalking, and for that received a consecutive sentence of 13 weeks. And finally, for count 8, which involved Jeremy Vine, Alex Belfield was found not guilty of stalking to cause alarm and distress, but guilty of simple stalking. You can hear more about what I mentioned about those particular counts in my previous videos, which I'll link in the description below. For count 8, that was an additional 13 weeks to run consecutively, which made a total consecutive sentence of 5 years and 26 weeks in prison, of which Alex Belfield will serve half before he's eligible for release. But there's a very important element to this appeal, in that both the single judge and the full appeal court can make what's referred to as a loss of time direction, if they consider that the application for permission to appeal was wholly without merit. In other words, it would be a hopeless application that had no grounds whatsoever of succeeding. I have no information, and there is no suggestion that the single judge has made a loss of time direction, and if the full court were to consider a renewed application, then again the full court would have the same discretion to make a loss of time direction. Now, of course, you're all asking, what is a loss of time direction? Well, it's exactly as it sounds, and it's as harsh as it sounds. The loss of time relates to any or all of the time that the defendant has spent serving their sentence whilst waiting for the outcome of their appeal. In short, what it could mean, or could have meant, is that if a defendant loses their application for permission to appeal on the basis that it was wholly without merit, Either the single judge or the full appeal court could make the direction that there is to be a loss of time served. In other words, at the very end of that appeals process, which has obviously taken many, many months by now, the court can make the direction that the time served has been lost because it's been subject to an appeal of sentence. If the court were to determine that it was wholly without merit, i.e. a hopeless application, the court could make that determination and the sentence would commence all over again from the point that the court refuses permission. That could mean all of the months thus far spent in prison was essentially all for nothing. So if you appeal a sentence from the Crown Court, the single judge on the papers and the full court can make that determination if they believe your application was with no merit. Now, as I said, there's no suggestion that I've seen or read here in the news to say that either the single judge or whether or not it's going before a full court as to whether or not that loss of time direction has been made. Of course, most of you will remember that Alex Belfield opted not to give evidence for his own defence before giving a closing speech, after which doubtless arguments would have been made or directions would have been put to the jury that that wasn't evidence, it was just a speech made by him, and it was his choice, of course, not to give any evidence, because this right to silence also includes the right not to give evidence. But there may well be an adverse inference directed to the jury, or simply put, that the jury may be able to draw an adverse inference from the defendant's failure to give evidence for themselves. Now, whilst the defendant cannot be convicted solely on their silence, it will certainly form part of it. But this is also a warning to others that inflict hatred and otherwise malicious messages to other people online and on social media, in that you can be convicted of these stalking offences even if you've never physically been near the person who is complaining of your activity, and you may well be prosecuted and you may well be sent to prison. And as the courts have highlighted in this particular case, the court takes a very serious and dim view of prolonged malicious communications and the effects that they have on other people's lives. So for those of you that are interested in any further developments to this appeal and what happens, I will let you know. For the moment, there doesn't seem to be any suggestion that there's been a loss of time direction, and so the sentence will continue as it did from the beginning, unless of course it goes before a full court and the loss of time direction is made. But as for that, you have to wait, and I will let you know in due course as and if I find out. So if you find these sort of update videos useful, please do hit that like button and subscribe. It really does help my channel grow, helping you to understand law here on this channel. And as always, I thank you for watching.